I want to put my house in a trust to my daughter, but I'm concerned my property taxes will go up to today's value. So it is right to be concerned about property taxes potentially increasing if you change ownership. This does happen when there's like two individuals, one buys the house from the other, that's a clear change of ownership. Or even, depending on where you live, I know it's like this where I am in Pinellas County, even if you form, say, an LLC to own an investment property, even if the owners on the title of the property are the same as the owners on the LLC, just by virtue of changing it from, say, two individuals to an LLC, the property will get reassessed for property taxes and potentially increase depending on, of course, when you bought the property and how much the value might have changed since when you bought it to what it would be assessed for today. However, when you put property into a revocable trust, you do that for estate planning purposes. There's definitely special wording that needs to be on the deed, so you should see an estate planning attorney, a knowledgeable estate planning attorney to prepare the deed. But when it's being done for estate planning purposes, again, revocable trust, you're not changing ownership. And I know at least where I practice law, again, I'm here in Pinellas County in Florida, when someone decides to put their property into a revocable trust, let's say by means of a general warranty deed, and they do this because they want their child, like in this question, their daughter or their children or someone else to be the ultimate beneficiaries of the property, well, then that transfer isn't a transfer that is going to spark a reassessment of the property. It's just going to go on just how it has. In fact, if it's your homestead, you still have your same homestead in that property. Nothing changes with your property taxes. Again, there is particular wording that needs to be both in your trust and your deed as it relates to homestead. In Pinellas County, the county appraiser's office even provided this language to attorneys, so they knew the specific language that needed to be included either in the deed or in the trust and in the deed in order for the homestead to be retained. Because I know this has also been sort of a long-standing battle with regard to the homestead. You don't want to lose the homestead quality of the property. Which is why a lot of attorneys will also still decide to do ladybird deeds to trust, which we do often in our office. That way it does stay in the names of the owner or individual owners during their lifetime. You can retain your property, say if you're married as a married couple, and then it can deposit into your trust. Your trust can be the beneficiary on the ladybird deed when you pass away. But ultimately, to answer your question, if you put your property directly into your trust, if it's a revocable trust that you're planning for estate planning purposes and you have the right language on the deed, then your property should not be reassessed for property taxes, and it wouldn't be here in Pinellas County if that's where you lived in Florida. All right, so I hope this answers your question. If you have any other questions about transferring properties into a trust, any kind of estate planning questions, elder law, asset protection, or Medicaid, please don't hesitate to contact our office. If you're in Florida, we're in Clearwater. We're at Cause Law Office, and the link is in my bio.